and welcome everyone to this kickoff event of our event series entitled Meet the Law. I'm super happy to see so many of you here today. My name is Laura Burgers, and my colleague Debadatta Boos and I organized this very first event in the Meet the Law series under the wings of our research group, the Amsterdam Centre for Transformative Private Law, which we abbreviate as ACT.
So, of course, this series, Meet the Law, is dedicated to the issue of sustainability in the meat and dairy industry, which, of course, has a focus on intensive farming, or what we generally call factory farming. Over the course of the series, we will address various issues related to this topic. And, of course, as one may know, it has so many aspects, and now Laura and I are joined by a whole team of organizing these events, which would be addressing all these various different aspects.
So just to give some examples, there's of course this issue of declining biodiversity exacerbated by deforestation, which results from the need for food for the livestock in factory farms. And something else, there's the aspect of labor. Only last week did the Financial Times report about terrible labor conditions in German factory farms. The headline was "The Human Cost of Cheap Meat." And we will also organize one event specifically about labor, sustainability in the meat industry in September.
Yeah, so we also have issues regarding labeling. So what private law scholars, it would interest private law scholars, of course, to think of what is issues of misleading labeling in this context. That would be on around the 31st of May. Then, of course, we also have events relating to the financing side of the meat industry, which would be our next event scheduled for the 14th of April. Yeah, so especially in the COVID-19 pandemic, we've seen many things evolve around the meat industry and sustainability, where we also see that there's a surge in alternative meats, so plant-based meat, lab-grown meat, and even plant-based dairy products. So they've risen by about 200 to 300% in consumption. This is, of course, because everyone saw in the news that the meat farms were COVID-19 hotspots, which also highlighted the frailty of meat supply chains, for example. And that has led many traditionally meat industry companies to invest in companies, again, like Impossible Foods and Beyond Meat. The Beyond's stock, for example, rose by 240% last year from the dip in March. So yeah, so as the time for the ill effects of meat consumption grows, the awareness on this grows, we feel that this is a very timely moment to start this lecture. So again, so one of the most intuitive aspects of this sustainability in the meat industry relates to animal rights. And we know that conditions for livestock in these factory farms are not really ideal or natural. And the other issue is, of course, the greenhouse gas emissions resulting from the meat industry, which is the biggest factor contributing to global food emissions. And both of these would be addressed today by Professor Abate. So yeah, Laura would introduce him now.
Yes. Professor Randall S. Abate is RECNIT's Family and Urban Coast Institute Endowed Chair in Marine and Environmental Law and Policy, and a professor in the Department of Political Science and Sociology at Monmouth University in West Long Branch, New Jersey, in the USA. He also serves as the director of the Institute for Global Understanding at Monmouth. He teaches courses in domestic and international environmental law, climate justice, constitutional law, and animal law. And he has published 6 books and more than 30 law journal articles and book chapters on environmental and animal law topics, with a recent emphasis on climate change law and justice. He's inter alia the author of Climate Change and the Voiceless, Protecting Future Generations, Wildlife and Natural Resources. And this is a book that I read personally with enormous pleasure and interest. And I actually intended to show you it before the camera, but then I realized it's actually in the office and I'm of course at home talking to you. So in sum, it's truly a great honor that we have Professor Abate here today, and I look forward enormously to his presentation.
Yeah, so after Professor Abate finishes his presentation, we of course have our very own Professor Chantal Mak, who will deliver a 10-minute response to the presentation. Professor Mak holds a chair with our university in private law and fundamental rights. And of course, one of her research interests is climate change. So after her presentation, we will enter into a plenary discussion. And yeah, that's all for now. So Professor Abate, the floor is yours. Thank you.
Thanks.
Thank you very much for that kind introduction. And I'm delighted to be here, getting my slides set up here. Really happy to have received the invitation from Laura to participate in this very exciting series. I'm thrilled to learn about it, and very honored to be the kickoff lecturer in this series. As I think Laura mentioned, I met Laura in a lecture that I delivered in the good old days, the way I refer to them now, a year and a half ago, pre-pandemic, when I was giving these lectures in person around the world. And I gave lectures in the Netherlands in June of 2019. And I was giving a lecture at Vrij University where I met Laura, and we've been in touch since, and it's been very exciting collaboration and great colleague to have. So very honored to have this opportunity, and I'm grateful to all the coordinators at University of Amsterdam to have put this together, and to provide this platform for my thoughts on this issue. So my scholarship comes at these issues from an intersectional angle, very much at the juncture of environmental law and animal law, and it's been a focus of my work for past decade, taking a look at how these two fields can better collaborate, coordinate their efforts around shared goals and challenges. And so this article, the basis of this presentation is on an article that's about to be published that is really my latest thinking on that theme of coordination between animal and environmental law efforts, and also very much centered on the climate change crisis and not just more generally for environmental protection. So I want to give you a roadmap of what I plan to address. The first thing I'd like to help you understand is this idea of the Anthropocene context and what I've termed Anthropocene Accountability Litigation. So the idea here is that the litigation efforts on both the environmental and animal law sides of the fence for these efforts are very much operating in silos. They're operating with this shared interest in addressing environmental harm in some way. Some focus more with environmental, some focus with more animal welfare concerns in mind, but ultimately they are targeting common enemies, a term that I've used in this article, the fossil fuel industry, the industrial animal agriculture industry. So I want to identify what I mean by the terms Anthropocene Accountability Litigation, common enemies, and how the US government is enabling both of these industries that were already immensely destructive on their own, how that's exacerbating the crisis that both of these industries are creating with respect to climate change and certainly other challenges. So I'll give you a very limited overview of the previous and pending suits that are going on against these two industries, and with the recognition that they're very much not coordinating with one another, even though they have very common ground, shared interests, shared objectives, without recognizing them as such. And so to propose some reform and how to proceed here, litigation is the leverage to get more systemic change, ultimately pressuring these industries with the threat of litigation. The ultimate goal is to prompt some legislative response in a top-down way regarding phasing out from our fossil fuel reliance and phasing away from our reliance on industrial animal agriculture. And so I offer some context where there has been success in that effort in other ways that could be readily transferable to to fossil fuels and animal agriculture to get us toward that just transition toward renewable energy and sustainable and plant-based food supply. So the Anthropocene context then is something I wanted to share. The idea that there is this new era that we've really been in since the beginning of the 21st century, known as the Anthropocene, which is really recognizing how humans have had a catastrophic impact on the world in which we live. Massive species extinctions, degradation of the atmosphere and the oceans, and many other environmental challenges that we have created and have essentially led me to characterize us as the virus. You know, the humans are really their own worst enemy in the environmental challenges that we're facing. These are climate change is the quintessential unnatural disaster in the sense that it is human caused. That's been widely recognized with climate scientists around the world on the IPCC. It's not something that's just a passing cyclical environmental reality that we have to contend with. We have created it, we are accelerating it. And so I wanted to give you some context that 50 years ago in the environmental movement in the US, we did a very good job responding to that reality of we created massive environmental problems that we then had to regulate effectively because we perceived them as crises to our public health and welfare. So massive efforts at the federal level to address air pollution, water pollution, hazardous waste contamination. And those efforts were very effective, largely because they were perceived as emergencies, something that was happening right in front of us and we needed to address to protect ourselves. And for some reason, that imminence of the threat is not happening with respect to the perception of the need to regulate climate change as an emergency and the need to transition away from fossil fuel dependence and industrial animal agriculture as driving forces of that emergency, even though it's not perceived as such. So I want to bring some of those lessons from 50 years ago into the crises we face with both of these industries accelerating the climate crisis. So the idea is that the starting point, governments are not doing enough in the traditional top-down way, the way the US did very effectively in the 1970s. That's not happening now. And so that has created these waves of litigation that I'm labeling Anthropocene Accountability Litigation that are really trying to step in and fill that void of non-regulation. And there's really two broad categories of what that is. Those of you in the Netherlands are quite familiar with the first category. The famous Urgenda case is the first type of accountability litigation where suits are filed against the government to raise the ambition of what the government ought to be doing to protect the public, but isn't on environmental matters, in this case, climate regulation. But this presentation focuses on that second category where there are efforts against the private sector to essentially driven by this notion of fairness, where there has been massive environmental impacts from particular private sector efforts, whether we're talking about the fossil fuel industry or industrial animal agriculture, where they are contributing significantly to these environmental impacts and not in any way called to account to pay their fair share of the damages that they're causing. So it's important to note that these cases are not limited to the climate change context, although that's going to be my focus today. This line of cases traces way back in the US, the lead paint industry, the asbestos industry, tobacco, opioids, more recently. They've all been subject to this kind of accountability effort, and the previous successes are quite instructive that they could be applied to making progress on the climate change front. So the focus then from there is that these litigation efforts can prompt a more efficient transition necessary for this, what's known as a just transition, which is a very complex notion, and my paper does not get into all the aspects of a just transition. It's a mass sectional mobilization that needs to occur, that's articulated in part in the Green New Deal in the US, where really when we talk about addressing climate change as the societal problem that it is, it requires mobilization across all sectors of society. This is not an environmental problem. This is just not just an economic problem. It's a social problem. It's a problem about getting to the root of the ills of capitalism and trying to restructure a way of proceeding that's going to be capable of responding to the breadth of the climate crisis. So there are racial issues and gender issues and worker protection issues and food justice issues all built into this. And so this presentation just focuses on those two pieces about fossil fuel dependence and industrial animal agriculture as two significant components of what that just transition needs to entail. So this idea of common enemies is really implicit in the term that you've got two industries that are causing massive climate change impacts, and they are also doing so in a way that is significantly enabled by the US government. There are regulatory gaps and exclusions galore for these two industries that they are able to operate in a way that avoids the regulation that they ought to be subject to. And to make matters worse, they are both benefiting immensely from generous subsidies to do the harm that they're doing. And one piece that's a big component of the recent line of cases against the fossil fuel industry is, in addition to those two first egregious realities, the third one is really the straw that breaks the back of these plaintiffs, motivating them to bring these lawsuits. These industries disregarded awareness that their activities were going to significantly drive climate change impacts. And not only did they just proceed with business as usual in the face of that knowledge, but they went beyond that and actively campaigned to minimize efforts to address those impacts because they saw that as a threat to their profits, and they engaged in public misinformation campaigns and efforts to insulate themselves from potential liability. And examples of that are climate denial science funded by the fossil fuel industry in the US, and the right to farm laws that were put in place to protect farming in the US in a way that is preventing neighboring landowners from bringing nuisance claims against those operations for the public health and environmental impacts that these operations have. It's essentially enshrining a right to harm the environment, neighboring landowners, public health, their property values, animals in these operations. And it's a very disturbing development. And that was actually most recently in October of 2020, those right to farm, interchangeable with harm, those right to farm laws the constitutionality was challenged, and it did reach the US Supreme Court on a petition for certiorari, which was denied. So basically the constitutionality of these right to farm laws has been upheld under federal constitutional law in the US. And that is quite troubling in the sense that the basis for challenging them was that having a right to farm law essentially amounts to a regulatory taking of these neighboring landowners, that they are essentially left with a property that is valueless due to being located near these massive polluting facilities. The impacts to their public health and quiet enjoyment of their property has been eliminated. So that's currently proceeding in the US as something that's perfectly legitimate, these right to farm laws. So in the US, this idea of enabler-in-chief is really quite disturbing. And we are witnessing, hopefully, fingers crossed, a transition of power this week in the US. But nonetheless, there was a problem in the US that far predated the Trump administration when we talk about a lack of action on climate change. So there were all kinds of efforts to enable the fossil fuel industry under the Trump administration. But it's important to note that regardless of whether there was a Republican or a Democratic administration in charge over the past 3 decades in the US, there was fundamental inaction on climate change. So you've got industries that are causing massive impacts contributions to global climate change, and in the US, they were not being regulated for those climate change impacts. They were regulated for other pollution impacts, but they were not being held to account for their contribution to climate change, and that's been true for 3 decades in the US. So there are also perhaps even more significant regulatory gaps and exclusions for CAFOs, concentrated animal feeding operations, these factory farms. They're largely exempt under the Clean Air Act and Clean Water Act for the significant contribution to air and water pollution that these facilities cause. And it's important to remember that EPA does have the authority under the Clean Air Act to regulate industrial animal agriculture greenhouse gas emissions, particularly when you consider the significant methane contributions from these facilities. And EPA has elected not to exercise that authority. That's a political problem that could change under the Biden administration. But like I said, there were other Democratic administrations prior to Trump that did not seize this opportunity to have EPA regulate these sources under the Clean Air Act for those contributions. And then the subsidies are just mind-boggling. When you think how much good can be done to address the climate change crisis if we just take this money that's being improperly dumped into the pockets of these deep pocket polluters and put it toward something that would facilitate the transition, put it toward research and development efforts to transition to renewables and sustainable and plant-based food supply, that would be an immense step forward. And part of that may be possible under the Biden administration. That remains to be seen. So the suits they've been just exploding against the fossil fuel industry in the past 3 years. So the basic concept behind these suits, as I mapped out in an earlier slide, is the notion that these industries not only have been causing significant contributions to climate change impacts, but they have ultimately done it without being financially accountable in any way. They're not being regulated from the government. These impacts are being borne by entities other than these industries. And ultimately, there is no financial contribution to respond to these impacts. So you've got counties and cities and states suing the common enemies, if you will, these carbon major fossil fuel defendants. There's a very common list of them that, to varying degrees, the usual suspects appear on all of these suits, ExxonMobil and Shell and BP and so forth. And the idea is that there are massive adaptation costs that these government defendants plaintiffs are facing. So if you're a city and you're facing massive expenditures to adapt to sea level rise, or to adapt to heat islands in urban areas, or to adapt to wildfires out west in the US, there's all kinds of costs associated with that are being exclusively borne by those governmental entities and their taxpayers, and nothing by way of a contribution from the fossil fuel industries that's driving these problems. So that notion of what they knew, when they knew it, and what they did, that's the deception piece that is a big part of these efforts. So it's not just about a public nuisance problem that they cause. It's more in these lawsuits about the common law actions of fraud and how the public was misled based on the information they had and what they did with it regarding climate change impacts. So these cases have been making significant progress. However, there's something happening right now, as this last point mentions. The US Supreme Court is going to review the fate of these cases, and we're talking more than a dozen nationwide, with cities, states, counties. This is going to the Supreme Court's hearing arguments tomorrow on this notion of the initial stage of these cases was successful in the sense that the fossil fuel defendants want these cases in federal court. And they made an effort to remove these cases that were initially filed in state court into federal court, because they are benefiting from valuable precedent at the federal court level, which says that these kinds of common law actions are displaced by the existing federal law of the Clean Air Act. So the idea here is that the plaintiff scored a victory in getting these cases back to state court. That's where things were as of a few months ago. Several federal circuits had said these cases belong in state court, not federal court. So what's being heard by the US Supreme Court now is this idea of, is that there's a very narrow procedural issue that's at stake as to whether these cases belong, whether these cases ought to stay in federal court, which would be a huge victory for the fossil fuel industry. That's where they want the cases to be heard, and that's where they will likely win these cases. If these cases went to trial at state court level, not only would there be a very significant likelihood of success, which I'm about to describe, but there's also the benefit of massive information being disseminated to the public about these cases going to trial, where the public learns much more about what these industries knew and what they did with that information, and really characterizes them for the evil that they represent in misleading the public to the public's detriment. So that is, we'll see what comes out of that after tomorrow's arguments and ultimately the court's decision. But prior to that procedural technicality that is now before the Supreme Court, I was quite optimistic about the likelihood of success of these cases at the state court level for these 5 reasons. So we're talking about a scale of contribution that is different from prior cases that have been brought in the climate justice common law line of cases in the US for the past 10, 15 years. That these companies collectively account for 2/3 of global carbon emissions, which is shocking. And the climate attribution science is another piece that's come a long way. Part of where the climate attribution science was in 2005 to 2010, that was in many ways the reason why some of these cases were getting dismissed. Now they're moving forward because of the strength of the science that has proceeded in the past decade. And then of course what they knew, and the idea that avoiding federal court enhances their chances to avoid that adverse precedent from the previous line of cases on federal common law. And then of course the standing obstacle is diminished here because these are governmental entities bringing the suit rather than private defendants. And the governmental entities have that benefit of the Massachusetts versus EPA reference to the special solicitude of states, that states and cities are able to bring these climate change actions on behalf of their citizens to protect their interests against these impacts. So as far as proposals for reform, the first step is the idea of public health and welfare and how that has worked so well in prior environmental contexts, and yet how it is not being used as effectively as it can in the context of climate change and industrial animal agriculture. So I talked about those successful federal environmental laws, how they were able to do what they did because of something that was readily perceived to be a public health threat. The pollution we were creating was an imminent threat to our health and safety: air, water, hazardous waste. Climate change is more of an imminent threat to our ability to survive and thrive on this planet, but it's not being perceived as such. So framing these the industry's impacts on both sides, fossil fuel and industrial animal agriculture, as an imminent public health threat is going to be very important for these theories to succeed, not just in the courts, but also with subsequent legislation. And tobacco and opioids provide a good platform for that. Those efforts in litigation were also about what these industries knew and didn't share with the public. And we're talking about a widespread public health problem that was perpetuated by industries seeking to profit from their product that ultimately was a massive public health problem. And they were preventing the public from knowing the amount of information they should have known about what a public health problem it was. So a very similar context to apply to fossil fuel and industrial animal ag. So that is one angle for these efforts to succeed more readily. The other is that we've got ample track record of effective mandatory phase-out regimes that both at the international level and at the US domestic level, and they've worked quite well. So the Montreal Protocol regime is really the crown jewel of how, when you've identified something that is dangerous to the public, that essentially threatens our ability to live on Earth, the international community mobilized very effectively to come up with an alternative to CFCs that were going to be ozone friendly. And unfortunately, they created one that's a severe climate change contributor, but that's in the process of being worked out now. But basically, that phasing out of the dangerous substance, the CFCs, over a relatively short period of time saved us from catastrophic impacts from stratospheric ozone depletion. And we saw a similar reality in the US with the phase out of lead and gasoline, really dangerous scientific evidence that pointed to the public health impact of lead. Lead was something that was an additive to gasoline to help it burn more efficiently, to make transportation more effective in gas-powered vehicles. But when the information came out about how dangerous lead was as a pollutant, the phase-out schedule was remarkably efficient to get lead out of gasoline under the Clean Air Act. And so this need to transition to renewables and sustainable and plant-based foods is every bit as urgent when we think about how significant these pieces are to why we face such a urgent climate crisis. When we look at the science, which is even more compelling than the science for climate change, more compelling than the science that we had for stratospheric ozone and lead. And yet we're still struggling to make those connections. And the market to some degree is facilitating some of these transitions as it should, but we can't rely on the market to get us out of this challenge. It's too pressing, it's too comprehensive, absolutely require very significant government top-down mandates to succeed. And then the COVID-19 pandemic, there's been a lot of writing on this already. And of course, I don't want to undermine in any way how tragic that this crisis has been for human health globally. But what we've learned from our response to the COVID-19 crisis is that we're capable of making very significant sacrifices and adjustments to get us to a better place when we talk about environmental protection, public health protection. How this year's global greenhouse gas emissions have been identified as the lowest since post-World War II. And that's a function of our response to the COVID crisis. Now granted, that was a very significant short-term response that is unlikely to be sustained at that level, but even a significant percentage of the sacrifices that went in to make that happen are still very much possible when we perceive the climate change crisis to be an emergency that it is. And then also how just in a very short period of the COVID pandemic, how skyrocketing sales of plant-based foods happened automatically, and how there were massive supply chain disruptions and COVID hotspots at factory farms that further illustrated how this is a fundamentally unsustainable enterprise and also one that is terrible for climate change. So you have on the fossil fuel side, some of these fossil fuel giants, because they suffered massive financial losses because of the pandemic, are voluntarily adjusting their portfolios to have more of a significant renewables focus. And that's not something they're doing out of the goodness of their heart. This is ultimately driven by economic realities. And this is something both movements can capitalize on, that we're already a few steps further down that path toward the transition that we wouldn't have been without the pandemic. So there's some momentum there to capitalize on, and both the environmental and the animal law movements are aware of that and are trying to leverage this. So the problem, though, is human nature, that so many of us, even those who are more environmentally minded, are eager to get back to normal, whatever that was. And what's important to remember is we don't want to go back to normal if we're serious about protecting environment and public health and animal welfare values. We certainly have to find a new normal when we come out of this pandemic. But the human nature tendency is to let's get back to the way it was. We've been disrupted. We want this comfort zone back. And that's going to be very difficult to overcome. And there's going to have to be very progressive government initiatives to overcome that tendency to return to the comfort zone of the bad normal that was. So the government has tools that can move us forward from there. And one, the easiest step is to disable those destructive subsidies. And there are certainly ample opportunities to support the transition to renewables and sustainable and plant-based foods quite readily. There's a recent example in Canada, in Winnipeg. There was, and this wasn't even a subsidy. This was federal financing for a new plant-based protein facility, and even that is better than nothing. But the government has the opportunity to do the right thing and needs to do these kinds of initiatives and stop being a part of the problem and start addressing the problem through how it channels its resources, whether it be through subsidies or merely financing for renewables and plant-based foods. And so there's all kinds of carrots and sticks that the government knows it has and can use effectively. Some easy examples of this would be something on the order of a tax break for buying electric vehicles, or a carbon tax on beef. There are all kinds of ways government can do this. Of course, some are more politically difficult than others. But then you've got another path that's already been blazed that can be capitalized on, and that is the transition from our reliance on coal is well underway and around the world and in the US. And so the just transition movement for fossil fuel and industrial animal agriculture is very much in line with how we were too heavily reliant on the destructive industry in coal, and how we needed to go to cleaner, more sustainable sources of energy. And that's very much the same path for other fossil fuels, natural gas and oil, and industrial animal agriculture. We just don't have to generate our food supply and our energy through these means. They're old habits that have to be broken. And so methane alone is a big part of the problem and a big part of the solution. So California is regulating methane emissions on dairy farms. And again, that's a small piece of the big problem. But even if that type of effort could be scaled up to the federal level, it would be massively positive outcome when you're doing that at the federal level with respect to addressing climate change mitigation more effectively than some other efforts that are being proposed. So I think that the failure to recognize just how impactful industrial animal agriculture is as a climate change problem is where the information needs to be more readily disseminated to the public. Prior to the documentary Cowspiracy in 2014, even as an environmental law professor, I wasn't as aware as I should have been of how impactful industrial animal agriculture is as an environmental problem, as a climate change problem. So there's a lot of public information campaigning that has to be done on this. I think we're much more likely to see progress on the fossil fuel side. There's much more awareness of the harms from oil and gas and their contribution to climate change than we see with industrial animal agriculture. But that, again, the two movements have that common interest. They're both very concerned about all of these impacts and the contribution to climate change, and that's a shared interest for these industries. So I want to leave that as a stopping point. I'm very eager to hear Chantal's comments and start a Q&A on what you've heard today. Thank you so much for your attention.
Thank you, Professor Abate, for the very insightful lecture and the very thought-provoking proposals as well. Of course, before then moving on to the discussion, we would like to give Professor Chantal Mak the floor for her response.
Yes, thank you very much, Devadatta, and thank you to both you and Laura for inviting me to be the first to respond to Professor Abate's wonderful lecture. Thank you so much, Randall, if I may, for this excellent kickoff of our Meet the Law series. There are 4 points that I would like to briefly introduce as topics for further discussion. And let me emphasize, as Devadatta said earlier, that my perspective is from the view of private law. So I'm sure that other people will offer additional questions from other fields, but my perspective is mostly from private law. So my first question is on the role of tort law in creating accountability for the companies that you mentioned in your presentation. And there I was wondering if you make a further distinction between compensation and prevention through tort law. So in your paper, you discuss a number of cases and also highlight what kind of claims they were. And I was wondering if you could elaborate a little bit more on to what extent it matters whether the parties ask for compensation in damages or for an injunction. And in particular, as to the latter point, also during your presentation just now, I was wondering then how tort law accountability could actually help us to make this step from a negative industry to a more positive phase out of certain regimes or positive measures towards creating more sustainable alternatives. And that is another question I would have. So how can tort law litigation, apart from pointing out what is negative in the industry, maybe also provide points of reference for something positive? My second question is a comparative one. So thank you so much for explaining to us the way that US law deals with this topic. I know you're also familiar with Laura's work in this field, and Laura, of course, looks much more from a European perspective. And in Europe, human rights have been quite often invoked in climate cases, such as Urgenda. Now, I saw in your paper you refer to one case in which human rights were indeed a factor, but otherwise it seems also from your explanation that in the US, the debate is much more in legal terms, in terms of private law, than in terms of human rights. So I was wondering, to the extent that you're familiar with the European debate, what you think about the human rights approach that is taken here, and what maybe could explain the difference in these two approaches. As a third point, I was wondering about the role of courts. So you mentioned that litigation can be a way to induce new measures, new legislative measures. And a big discussion that we have had here in the Netherlands surrounding the Urgenda case is whether it is actually for courts to do so. So are courts the right site for having this conversation about climate change and what should be done to reduce greenhouse gas emissions? And I was wondering about your view on this. So I see the strategic importance of this kind of litigation, but then there's also the normative question of whether we should go through the courts to get these legislative measures. Then as a final point, you introduced the concept of a just transition and also gave us some insight into what this means. And in your paper, you also argue for a common theory to address issues of climate justice. I was wondering to what extent the view on businesses that we take is also part of this idea of justice, because we emphasize a lot what businesses are doing wrong and all the negative impact that businesses have. But to what extent should we maybe also try to shed a more positive light on businesses in order to try them to try to get them to voluntarily adopt certain more sustainable strategies? And I must say, I was nodding when you mentioned, well, these companies such as Shell, they were switching their strategies in times of COVID-19 because it was more profitable to them. I'm afraid that this is largely an explanation indeed. But still, I was wondering in legal strategies towards this just transition. What could we do as legal scholars to also incentivize businesses to take a more positive view on what they can do next to their economic goals, but also as important social actors. So I'm very much looking forward to your answers and to the further discussion. Thank you.
Thank you so much, Chantal. Then I'm now looking at, and of course also thank you very much, Professor Abate, for both of your presentation and your response. I'm now looking to the third person I should thank, namely Jean. Perhaps you can now stop the recording, Jean. Thanks so much.